In my first video, I explained the purpose and the objectives of this YouTube channel. And I also gave a brief introduction to the concept of fairness of a criminal trial. This video is a continuation of the same subject. I intend to make a brief presentation today on the role of the prosecutor in a fair trial. The purpose of this video is not to discuss the powers, functions, and privileges of the Attorney General or State Counsel, except to show Crown Counsel who come to criminal courts, prosecute cases, they have certain responsibilities and certain duties. And that is the purpose of this video. Now we all know that the general function of the State Counsel is to State Counsel who prosecutes is to adduce evidence and get a conviction of the accused, prove the charge against him, and secure a conviction. Now that's a general function of a State Counsel. But in this exercise, not all avenues are open to them. They don't have an unfettered freedom. Their freedoms are restricted. What I said was the general function. But there is a primary function, a golden rule, a hidden rule, that is to assist court in holding a fair trial. Now to understand this better, let's get back to the definition of a fair trial. A fair trial is a trial held by an impartial, competent judge according to legal procedure. Prosecution conducted by a fair prosecutor in a calm judicial atmosphere without causing any prejudice either to the accused or to any of the witnesses. You will see that the word fairness is used in this definition. That's the reason that I chose this topic today. And that fairness, law in its wisdom, has been used in relation to the prosecutor. So in Sri Lanka, we have rules promulgated by the Supreme Court. Like the judges' rules in England, we have Supreme Court rules promulgated way back in 1988. In those rules, there is a set of rules which deals with ethics and etiquettes of attorneys at law. Rule 52 is relevant. What does it say? It requires any attorney at law who appear for the prosecution to bring to the notice of court any matter which, if withheld, will result in a miscarriage of justice. Now we have in Sri Lanka this express provision which imposes a duty as well as part of the ethics of Crown Counsel to bring that to the notice of court. The salient features of the subject will have to be extracted from the judgments. Express positions are less and little and few and far between. I have found out a recent judgment, Sugath Karunaratna versus AG. These judgments I will give in the description box, the name as well as the reference. In this case, this was a rape case. Justice Aluhare, President's Counsel, set 10 points which are which concern the State Council. The function of the State Council is to present the case, present the prosecution effectively. That's one. To the best of his ability, in order to secure a conviction. Those are the general purpose, general functions. The prosecutor, however, is an office of the court, is an officer of court. His role is to assist court to dispense justice. It is not for the prosecutor to ensure a conviction at any cost, not at any cost, but assist court to elicit the truth and see that the justice is meted out. The prosecutor is not expected to keep out relevant facts either from the court or from the defense counsel. If he is aware of matters which are favorable to the accused, it's his duty to make them available to the defense as well. Now, this judgment is a very exhaustive judgment delivered by Justice Aluhare. Now, I shall take you through 3 cases in 3 different jurisdictions, rather 3 countries, in 3 different countries. First one coming from Canada, from Supreme Court of Canada. This is Rex versus Stinchcombe. I hope that I pronounced this correctly. In this case, while the trial was going on, the police recorded another statement from one of the witnesses, a second statement from one of the witnesses, and that was made available to the Crown Counsel. Case went on. After the prosecution case, the Crown Counsel told the defense counsel, I am not calling this witness, not reliable. But he did not make that statement available to the defense counsel. He made an application for that. That was denied, and his application was disallowed. Eventually, his client was convicted. But at the appeal, all the matters were brought to the notice of court. And it was found that that particular statement was very much in favor of the defense. So then the appeal court judges held that it was the bounden duty of the Crown Counsel to have brought that to the notice of the defense counsel. Now, this case is a landmark judgment on fairness of a criminal trial and duties and responsibilities of a Crown Counsel. Was studied well by the Supreme Court of South Africa, Justice Lee Rocks, in the case of State versus Botha. It's a South African case. Analyzed Stinchcombe case and extracted 6 principles out of it. It was a very difficult exercise anyway. However, it was done. These principles have been found in Sri Lankan case of Wijepala versus Attorney General 2001, 1 SLR, page 46. Justice Mark Fernando, Justice Mark Fernando, after a very exhaustive judgment, referred to all those South African cases as well as Canadian cases, and brought these 6 principles, which he believes are very vital. Let us now see what are those 6 principles. What those 6 principles are. The information in the police docket does not belong to the police. It belongs to the public. It's a public document. There is no duty on the accused to assist the prosecutor. After all, prosecutor is his adversary. There is a general duty on the prosecutor to make disclosures of matters favorable to the accused. Now that was, in fact, Stinchcombe case emphasized on disclosure. That was a case which has dealt with the disclosure in full measure. Except that the Crown Counsel can exercise his discretion not to disclose certain matters which are privileged. Now this exercise is reviewable by the presiding judge, and he can either overrule the Crown Counsel or he can hold with the Crown Counsel. Disclosure is a continuing duty. So the classic example, Stinchcombe case. While the case was going on, normally these things are disclosed at the beginning of the trial. But here, during the course of the trial, a further statement was recorded and brought to the notice of the Crown Counsel. So, since it's a continuing duty, he should have given it to the defense counsel at that point of time, which he didn't do. And statements made by all witnesses, whether they are to be called or not, should be made available to the defense. You must not suppress anything. You must not conceal anything. Notes of investigation of police officers also should be made available to the defense. Finally, I refer you to a judgment, a landmark judgment from the Canadian Supreme Court. Their lordships described the prosecutor as a quasi-minister of justice. What their lordships meant was that he holds a quasi-judicial office. His primary interest is not to secure a conviction, but to dispense justice. He represents public interest. He is not the lawyer for the police. You will now see that a prosecutor who is prosecuted in a criminal court has enormous power and responsibilities. You all know, corollary of power are the duties. If you breach the duties, you are breaching the ethics and abusing power. We will meet again. I shall conclude. Thank you very much.